Good afternoon, everybody. Today we're going to talk a little bit about trial time. For those of you who are attorneys, much of this will be very, very familiar. For those of you who are adjusters, this is something oftentimes that's tangential to what you're doing, but I think important to know so that you can coordinate your efforts with your attorney and if you're not yet represented, to prepare, to get prepared for whenever it is you become represented. So we're going to address a lot of questions today and in a future conference or webinar. What can you expect when we're actually down at the trial? How do you prepare? What kind of evidence do you obtain? How is it authenticated? What can get in? What's going to be left out? What are your rights? What are you entitled to do at trial? What are you entitled to in terms of accumulating evidence? What are you not allowed to do? What are your responsibilities? What kind of information must you provide to the other side? What are you going to have to do to get evidence in? What do you actually do at trial time? And what are your burdens of proof? Who has to prove what and when? Well, loosen your tie. Things are going to be pretty casual down at the WCAB. We're bound by the common law and statutory rules, but what's going to really happen is the judge is going to basically play father knows best and is going to be very fast and loose with the rules of evidence in general. There are rules, however, that will be followed. And let's take a look at the situation from a 36,000 foot view. We're way up in space here, taking a look down. The parties are going to submit for decision all matters properly at issue, and we're going to have to produce evidence that's relevant. We'll talk about what relevant really means later on. We're going to submit witnesses, submit depo transcripts, submit various documents that are allowed in, many medical reports potentially, payroll statements and other employer records, and anything else that is relevant. Let's just say we're going to talk about relevant, admissible, we'll determine how to make documents admissible, and essential to making the determination. The judge is going to determine what's relevant. The judge is going to determine what's admissible, and the judge is going to determine what is essential to the case. And which makes a lot of sense because it's going to be the judge who's going to be relying on this information or, for that matter, deciding not to rely on this information. Post-trial, the judge is going to do his or her findings of fact within 30 days of the case being submitted. Hopefully soon thereafter, they will render their F&A and provide exactly the reason why the award was made or why the award was not made. And thereafter, a way to recon if and when somebody decides that they are too aggrieved to accept the opinion of the judge. Now, if you go to criminal law or you go to the civil court, there are lots and lots of fancy rules that absolutely positively have to be followed. They're very stringent, but we don't do that. As I suggested earlier, we're not bound by the common law. We're not necessarily bound by the statutory rules of evidence and procedure. We will use them as guidance, and sometimes judges will rely on them expressly, but it's really fast and loose with a few exceptions. Because, as I said, the judge is going to try to be father knows best. They're going to be aimed at determining what is quote-unquote best calculated to ascertain the substantial rights of the parties, basically looking out for everybody's interest. Of course, those of you who are on the defense side are aware, I'm sure, that the interest of the applicants are oftentimes more focused upon than the defense, but that's the way it is. No fancy rules here, no informality of any proceedings or the manner of taking of testimony shall invalidate any order, decision, or award. Objection, hearsay, I'll take it in. That's often what happens. We need to lodge our objections to evidence and testimony coming in, and we'll talk more about objections, but oftentimes, in fact, typically, the response is the judge will say, so noted to the objection, and then say, I'll let it in necessarily, or I'll let it in and just decide whether it's worthwhile later on after I've heard all the other evidence. Now, We do have constitutionally protected rights such as due process, and this informality of the down at the board is not going to trump, get a joke, a really bad joke here, our constitutional rights. Not all evidence is going to be evidential. It has to have some probative force, meaning it has to have, in some way, shape, or form, prove or disprove a fact that issue. And even hearsay, which we'll talk about, will be allowed, but in a limited way when best calculated to ascertain the substantial rights of the parties. If not, also, it's not going to be admissible if it's obtained via fraud and deceit. Think about, and we'll talk about a couple examples of this, but obtaining video sub rosa fraudulently, or Facebook friending. I don't know if you've had any experience with internet research or sub rosa, but friending, for example, an applicant is deceitfully to obtain access to their non-public page is considered a no-no, and you can get in a lot of trouble for that. Now, the judge does have to follow some rules. As I suggested, due process, fair and open hearing, the right to present evidence, the right to present witnesses, the right to cross-examine opposing witnesses, the right to present a rebuttal evidence. And we can expedite things with a bifurcated trial. Now, I don't know if you've had any experience with bifurcated trials. Oftentimes, folks don't because the judges don't like them, but they are an option that should be explored, and they can save a lot of money. According to the code, the parties are expected to submit for decision all matters properly at issue for a single trial. That's why you don't see bifurcated trials very often. However, the judge may order that issues in a case be bifurcated and tried separately, as long as the party requesting it shows good cause. So, for example, let's say you have a statute of limitations defense, or a going and coming rule defense, or an intoxication defense, and you want to decide whether or not to proceed with any further discovery. You've done your discovery in terms of the SOL, or you've done your discovery for purposes of the going and coming. Do you need to do any further discovery? Do you need to, find out about apportionment? Do you have to find out about the level of PD? Do you have to really figure out about TD? Probably not. Not, for example, if you win the SOL defense. So then all your discovery is over. You can close the file. If you lose, you then start the discovery train. So in that way, bifurcated trials can save a lot of time, can save a lot of money, and are something that should be considered regularly down at the WCAB district office. Who decides whether or not there's going to be a bifurcated trial? You guessed it, it's going to be the judge. However, if the judge rules against it and we've got good reason to proceed with a bifurcated trial, we can consider a petition for removal. They do save time, they do save money. Similarly, stipulating to a witness's testimony can do that. Let's say it's completely agreed as between the defense and the applicant that there was a car accident and the red car ran into the green car. It can be stipulated on the steps and issues that there will be testimony to that effect, and we can avoid having a witness come down and testify to that effect. Similarly, we can ask the judge to take judicial notice of evidence that is not provided. A lot more about that later. However, if we're down at the board and we don't have the evidence or minimal or insubstantial evidence to prove our case, get ready for sanctions. We see this most often with lien claimants, I'm happy to say, but then again, I'm a defense guy. By the way, this provision that there will be sanctions if you show up to trial and have no or minimal or insubstantial evidence is actually an en banc decision, the Torres decision. So this is real serious case law. It came down in 2012. It must be followed by the WCJs and WCAB panel decisions. I don't think that's going to change anytime soon. In fact, I suspect It's never going to change, at least during our careers. So we want to introduce testimony and what? Reports of the attending physicians, reports of the investigators appointed by the judge, and judges can appoint investigators, reports of the employer, timesheets, etc., properly authenticated copies of hospital records. We'll talk more about authentication later. All publications of the DWC, all publications of the California and U.S. government, excerpts from expert testimony from depositions, relevant portions of medical treatment protocols, MTUS, VR expert reports, etc. Let's talk about these. Reports from the attending or examining physician. They've actually got to have the examination. Believe it or not, we sometimes have situations where the doctor has not examined the applicant, where they've had a third party examine the applicant, or for example, they've done it telephonically. The only time that the physician can avoid having examined the applicant is if the applicant is dead, which I think provides them a pretty good excuse for not doing so. If they're dead, or if we're talking about utilization review, then there need not be any examination. We said earlier that we're going to talk about the authentication of records. It's something that we should consider, but it's nothing that we have to take too terribly seriously, necessarily. There's a case that came down. The judge said, I'm not going to allow the payroll records in because the defense failed to lay a foundation down at trial. They failed to properly authenticate the payroll records. They, for example, failed to have a witness from the employer say, yeah, these are payroll records. These are the type of payroll records that we produce in the course and scope of our work, and these are legit. You can rely on these, judge. There was nobody also to testify to the trustworthiness of the records. So the judge said, we're going to exclude those. We got appealed and said, no, they're admissible because, as we suggested earlier, the judge is not bound by the rules of evidence. The judge can, without the authentication, can still, because he or she is the expert, can weigh out the authenticity of the records, can determine whether they're relevant, can determine whether they're trustworthy. Because it's a judge who's making this decision. It's somebody who's down at the board in trial every single day. It's not some unsophisticated jury. And that's really the explanation as to why we're very, very fast and loose with the rules of evidence down at the board. We want to have we enforce the ticky-tack rules with the jury because it's expected that the jury is going to be unsophisticated and not know what to do with evidence that turns out to be irrelevant, or it turns out to be hearsay, or turns out to be in some other way prejudicial. By contrast, we think of the judge having the knowledge of evidence, having knowledge of how trials work, and having experienced the workers' compensation system for years, if not decades, is in a better position to determine whether the evidence, how the evidence should be weighed. Nonetheless, make sure it's always best to have witnesses there to authenticate the records that you're submitting into evidence. Copies are okay. Photocopies are okay as long as it's non-erasable, and it'll be admissible so long as the additions, deletions, and changes are not permitted. It can't be done by some sort of technology or photocopy. On the flip side, microfilm, microcards, miniature photographic copies, or reproductions or enlargements are not admissible. Once admitted, the copy is presumed to be accurate. So when you submit a medical report, a photocopy of a medical report, the judge is going to say, okay, I believe that. It's only going to be, I presume it's accurate, and everybody's going to accept it as accurate until another party attacks that presumption and demonstrates with evidence that it is inaccurate or unreliable. At that point, the burden shifts to prove otherwise by a preponderance of evidence. What's a preponderance of evidence? 50% plus a little. It's not even that's going to the 51-yard line. It's going to the 50-yard line and a smidge. Got technology. You're submitting the records, all the records via technology. Doesn't matter. Your judge who's a million years old who doesn't like technology, or who's like me, 54 years old and still not great with technology, can demand a hard copy. No VR testimony must be in reports. We know that statute just recently came aboard, except for good cause. So normally we're going to have our VR experts information and opinions submitted via reports and deposition testimony. Deposition testimony. We can have them testify down on the board if we have good cause to for that and convince the judge that we have good cause. What's good cause? I don't really know, but I can tell you what it isn't. And here's what it isn't. Good cause shall not be found if the vocational expert witness has not issued a report and the party offering the witness fails to demonstrate that it exercised due diligence in attempting to obtain that report. In short, you're down at the MSC, the applicant says, or defense says, we want a voc rehab report entered into evidence, and the judge says, where is it? Well, we haven't gotten around to do it yet, but we'll get it to you later. And the judge says no, and the applicant, and then the party says, well, I'll tell you what, we'll offer the vocational expert up as a witness. At that point, the judge is going to say, that's not good cause. You lose that one. Arguing that the VR report is inadmissible. We won't go over the list of requirements for the admissibility of a VR report, but it's longer than your arm. And if you've got a VR report that you believe you want to have stricken, and I suspect and believe that's going to be all VR reports when you're dealing with an Ogilvy or LaBeouf type of situation, you're going to want to compare your opposition's VR report with the labor code and the CCRs. Hearsay. We talked about hearsay a little while ago. What is hearsay after all? We hear about that in all LA law and all the movies and TV shows about television, or about the law. But what exactly is hearsay? Hearsay is an out-of-court statement produced to prove the truth of the matter asserted therein. Okay, what the heck does that mean? It means somebody said something out of court, and somebody who's testifying wants to say, this is what the person said, and I'm going to prove let me rephrase this. Joe witnesses a car accident. He says the red car ran into the blue car. Joe tells somebody else that somebody else is the witness. The witness testifies, Joe said that the red car ran into the blue car. Joe's not saying it in testimony. It's testimony. It's being stated secondhand for the purpose of proving that the blue car ran into the red car. That's hearsay. And in general, in other courts, that is in the civil court and criminal court, it's inadmissible. It's inadmissible because it can't be checked. We can't cross-examine Joe. But in the regular courts, there are a gajillion exceptions to the hearsay rule. When I was in law school, it took me several days took my civil procedure class, probably several weeks to go through all of the exceptions to the hearsay rule. Happily, we don't have to do that today or ever because, like I said, generally speaking, hearsay is acceptable to establish any fact. Now, let's not get crazy. Let's not but first, before I say that, if you are dealing with a hearsay situation, if you do want to prove that somebody said something and want to prove out of court, and you want to prove the truth of that statement, get them into the courtroom, list them as a witness, and have them testify. That way you avoid any objections that it's hearsay or double hearsay or triple hearsay. And if you can't have that witness available, you're going to want to be able to prove that they are unavailable and that you gave every reasonable effort to get them available. Now, what about double hearsay or triple hearsay? Don't medical reports have double hearsay? The doctor says, okay, The patient said X, Y. The patient says it hurts their left arm when they jump on their leg. That's an out-of-court statement offered to prove the truth of the statement. Nevertheless, because the WCAB favors the production of written reports as opposed to having doctors come down to the board and testify, this is considered not a problem. Medical reports. Now, in terms of double hearsay or triple hearsay, we're not going to let it go crazy. We're going to still have some rules with regard to hearsay and keeping some hearsay that's totally unreliable out of the case or out of evidence. Here's the case that came down. The applicant told the doctor that the brake lining he was working on contained asbestos. There was no evidence that the doctor knew anything about the brake linings, and there was no evidence that the applicant knew that the brake linings were made of asbestos. Apparently, the applicant was told by somebody else. There was also no evidence of exposure. The medical evidence was precluded because we had triple hearsay here. And let's just read the explanation from the court. There is no evidence that the QME himself knows anything about the composition of the actual brake linings worked on. Even assuming the applicant made a direct statement to the doctor about the asbestos exposure, there was likewise no evidence of applicant's own competence with respect to knowledge of brake lining composition. Such double or triple hearsay is not the sort of evidence upon which reasonable persons customarily rely in the conduct of serious affairs. They are the untested statements or surmised statements of persons of no proven competence to make them and are in themselves insufficient to sustain the findings of material facts. So what did we deal with? Somebody told the applicant, we don't even know who that is, and we certainly can't cross-examine them to make sure they were accurate or that they were believable. Then an applicant reportedly told the doctor, an applicant may have not been available for cross-ex, and then the doctor repeated it in writing. We've got three levels of hearsay. Triple hearsay just isn't going to be accepted in, I don't think, in most cases. So if you're facing that type of situation and you want to get the evidence in, again, get a witness, or rather get the person who uttered the out-of-court statement in as a witness so that they can be cross-examined and then so that the testimony can come in. An offer of proof. What's an offer of proof? Well, it's a way to save money, time, and energy. We can avoid calling a witness by stipulating to their testimony. The applicant's going to say X. We believe they're going to say X. We agree that the applicant is going to say X. We can keep the applicant from coming. We can avoid the time and expense of having the applicant come down to trial to testify to X. Stipulated offers of proof are sufficient to support an award. So proceed with caution. If you had any reason to suspect the applicant's testimony, don't be stipulating to it because you're going to want him or her down at the board testifying so you can cross-examine them and make sure that they're telling the truth and make sure that the judge determines whether or not they're telling the truth so that the judge can not only review their words, but look at them and see if he thinks that they're lying or telling the truth. Similarly, a stipulation is limited to what the applicant or what the witness would say, not the truth of the testimony. We can still rebut it. Judicial notice. I touched on judicial notice a while ago. The sun sets in the west. I suspect everybody in this audience will agree that the sun sets in the west. Seawater is salty. And I think, once again, everybody here and everybody you and I know will agree that seawater is salty. Well, that's what judicial notice is. The judge will take judicial notice or allow in a representation of fact that everybody agrees to, that everybody knows, that is just common sense, that that even an applicant's attorney would understand and agree to. There are actually things that pieces of information that the judge must take judicial notice of under the evidence code. California and U.S. law, you don't have to lay a foundation. You don't have to get evidence, a witness to testify that as to what the California law or the U.S. law is on this, that, or the other thing. The judge will take judicial notice of that. Similarly, city and county charters, regulations of state and federal agencies, the California codes of professional conduct and rules of procedure, English words, phrases, and legal expressions. If the judge can look it up in a dictionary, we can have them take judicial notice of it. Universally known matters. Again, seawater is salty. The sun sets in the west. As long as a reasonable person can agree to that or will know the answer to the question, then the judge can take judicial notice, or actually must take judicial notice. Discretionary, the judge has some discretion as to whether to take judicial notice to a number of other things under the evidence code. The law of sister states, resolutions and private acts of the United States and the California legislature, regulations and legislative enactments of public entities, official acts of the legislature, executive branch, and judicial departments of the U.S. or any state, court records, federal rules from local federal rules and sister state rules, foreign law, matters of common knowledge, and matters subject to immediate and accurate verification. For example, the permanent disability rating schedule. You don't have to offer it into evidence. Everybody agrees that the permanent disability rating schedule is the permanent disability rating schedule. That's commonly known. Similarly, the PDRS is actually a regulation. It is a California state regulation, and as suggested just earlier, that is a mandatory. That is an item that the judge is required to take judicial notice of. So you don't have to offer up the PDRS as evidence. You don't have to have somebody testify that this is the PDRS and this is what we rely on. It will come in. Prior decisions in the same case. Let's say there have been multiple decisions. Let's say you had a bifurcated case and you went to trial on the issue of the going and coming rule in the first trial, and you lost. So you continue to conduct discovery, get witnesses, etc., and you go to trial for a second time. You don't have to retry in the second trial the issue of the going and coming rule. The judge will take judicial notice of that prior decision. Similarly, NPNs approved by the WCAB, the judge can just take a look at the website and will take judicial notice of anything in there. Similarly, the DWC-1 claim form. Give you an example, the applicant testified to no prior injury. In this case, the judge took a look at the WCAB's records, found the medical records from a prior claim, and the applicant was impeached per judicial notice. Now, when we're down at trial, folks should stay awake. Seems obvious, but that's not necessarily always the case. In fact, I can tell you 25 years ago when I took my very first workers' compensation deposition, it was in Palm Springs. It was about 106 degrees, I kid you not. It was hotter than Hades. It made everybody very sleepy, and about halfway through the deposition, I heard some snoring. Applicant's counsel fell asleep. Now, I was fresh out of law school and had no idea what I was supposed to do at this point in time. Do I wake him up? Do I discontinue the deposition? And so I did the only thing I could think of to do. I whispered, and it worked out just fine. Well, similarly, when we're down at the board, we need to stay awake. When we're going to trial, we need to stay awake. We want to object when there's a reason to object. If you don't object immediately, timely, you waive the objection. This is true of any kind of objection: hearsay, privilege, failure to disclose submit the proposed evidence, failure to disclose it before or at the MSC. Objection: this information is cumulative. We've already had 3 witnesses testify to it. It's objection. It's irrelevant, etc. Um, this is a rule that the board is very serious about. I said that we're going to be fast and loose with a lot of evidence rules, but waiving one's objection is one that's firmly established. No rule of procedure is more firmly established than that which requires a party who considers making an objection to the admission of testimony. It would be manifestly unfair and unreasonable to permit one party to remain silent and by his or her silence to tacitly acquiesce in a proceeding and thereafter to allow him, after an adverse decision, to nullify this decision by insisting upon an objection. So if you got an objection, object or waive it goodbye. Lights, camera, action. You might be able to actually film your trial. It happens rarely. But this is the land of Hollywood, so what the heck, let's give it a shot. The judge is not going to want to do it. And it is up to the judge as to whether to allow it, to eliminate it, or if it does start, to terminate it. I've never met a judge who thought it was a good idea. Nobody really wants to be videotaped. It can be very embarrassing. And particularly since we're down at the WCAB and the rules are kind of fast and loose, nobody wants to be seen fast and loose in come trial time. Like I say, it's up to the judge. But if you want to do it, if you've got a good reason to do it, first off, you better come up with a really good reason. And the judge is going to consider a whole host of things. And this list is also as long as your arm. The importance of maintaining the public trust, of promoting public access to the system, whether the other parties oppose or support the request. The nature of the case. Is this a rape case as opposed to a broken leg case? Obviously, if it's or an HIV case, obviously, if it's of a more private nature, they're going to be far less inclined to allow the filming. The rights of the privacy of all participants. The effect on any minor. They're going to want to protect the rights and privacy of children. Any effect on law enforcement activity in the case, any effect on subsequent proceedings, et cetera, et cetera. Security of the trial. Are we going to need extra security if this thing is video recorded? Interference with neighboring hearing rooms. If we've got lights, camera, and action, is it going to disturb the courtrooms around the courtroom where we're doing it, et cetera, et cetera. Basically, any factor that the judge deems relevant. Notice that this list gives a lot of good reasons for the judge to restrict or disallow the filming, and that's why we so rarely see this happening. Nevertheless, if you insist and you want to be Steven Spielberg, here's what you got to do. You have to make a written request to the presiding judge, and you have to give them at least 5 days before the trial. I recommend you give them a month before the trial. They're not going to like you very much if you spring this upon them at the very last second. At that point, the judge or the WCAB district office is going to let everybody know that the request has been filed, and the judge will rule on the case or rule on the decision. In all likelihood, giving all the parties an opportunity to debate whether it should happen at a separate hearing. So, at our trial time equals work time. In other words, we have to meet our burden of proof to get evidence in. According to Labor Code Section 5705, the burden of proof rests on the party or lien claimant holding the affirmative of the issue. Meaning, if you want the judge to believe it, then you need to prove it. And you need to prove it, in most cases, by a preponderance of evidence. As we discussed earlier, a preponderance of evidence is 50% plus a smidge. That's the unofficial definition. The official definition is evidence that, when weighed with that opposed to it, has more convincing force and greater probability of truth. As I suggested, 50% plus a smidge. When weighing the evidence, the test is not the relative number of witnesses, but the relative convincing force of the evidence, meaning you may have lots of lousy witnesses, but one good witness will win the day. So there'll be times when I've seen situations where parties have listed a whole host of witnesses, and not only does this tick off the judge because they know it's going to take forever, but it's oftentimes cumulative, and it often suggests that the party who's listing all these witnesses doesn't think that their witness, that any one particular witness, is going to be a good witness. If the other side has a good witness, that's probably going to win the day. So he who wants something goes first, and in workers' compensation, it's going to be the applicant. They must prove injury or death, AOE, COE, and causation by a reasonable medical probability. Until that happens, the defense need do nothing. And I've seen a number of cases in which the applicant has proceeded, and the applicant will proceed first because they have to prove these various factors, injury, AOE, COE, and causation. I've seen situations in which the applicant has gone first, presented their evidence, and the defense has turned to the judge and said, I'd like a decision. I'd like a decision as to whether I need to proceed. Meaning, I don't think the applicant has actually proven their case yet. And if the judge rules with the defense, that means that's the end of the day. What's a reasonable medical probability? You often hear that medical reports must be true to a reasonable medical probability. And when I give presentations on this, I often say it's largely magical words, hocus pocus, abracadabra. That's not really the truth, but it's close enough to the truth. To be honest, it's a very tough question. I have seen law school legal journal articles dedicated to the question, what is reasonable medical probability? But I can answer that question in the negative. Quoting the Escobedo decision, I don't remember the Escobedo decision. It was an excellent apportionment case reviewing Labor Code Section 4663. It came out exactly a year to the day of SB 899. So this came down April 19, 2005. And if you're not familiar with Escobedo, I strongly recommend you read it. And we're going to talk about Escobedo, not today, but probably in our part 2 of this presentation, Trial Time. Anyway, so back to the question, what is reasonable medical probability? A medical report must be based upon a reasonable medical probability, meaning it must not be speculative. It must be based on pertinent facts and on adequate examination in history, and must set forth the reasoning in support of its conclusions. In other words, the doctor can't just say, well, I like both of the parties, so I'm going to split the PD 50-50, half industrial, half non-industrial. No, the doctor's going to have to say, based upon my examination and the relevant facts, and I don't know, the MRI and the history given to me by the applicant, it's true to a reasonable medical probability that 50% was work-related and 50% of it was not AOE, COE. Do the magic words reasonable medical probability have to be used in the doctor's deposition or in the doctor's report? No, they don't. However, it really is helpful to have them there. What's the applicant's burden? Well, as I suggested earlier, they must prove every element of their claim, the AOE, COE, and causation entitled to the various benefits. Must the employer assist? Sometimes the applicant needs help, particularly in a pro-per case, and the judge may ask the defense to provide a little assistance. The answer is absolutely positively not. We are not representing the applicant. The applicant is representing the applicant, and should the applicant be so inclined, the applicant can be represented by his or her attorney, but we don't do the job. This came down via a 2016 case in which it was asked, can the WCAB order the employer to help the applicant unrepresented obtain a required form to subpoena records? It was held absolutely not. That's not our job. And the burden is on the applicant to do his or her discovery. It's only the defense's job to respond to that discovery, to counter it, the applicant's evidence. So like I said, the employer has no burden until the applicant succeeds. Once the applicant does succeed in proving AOE, COE, causation, etc., then the burden, and only then does the burden shift to the employer to come up with an affirmative defense, SOL, going and coming, intoxication, what have you. This is also true with apportionment. If the applicant proves that there is an approximate percentage of permanent disability directly caused by the industrial injury. This is from Labor Code Section 4663, by the way. It's then the employer's burden to prove the approximate percentage that was caused by non-industrial factors. In short, the doctor provides substantial evidence as to WPI. That WPI is rated out for by the 1.4 modifier, occupation and age. Turns out there's 50%. The applicant has now proven that. Now it's up to the defense, the burden on the defense to prove the percentage, if any, that is non-industrial. What if there's an award of ongoing benefits, such as temporary disability? Then, if there's evidence that that disability has discontinued, the burden lies with the employer to prove termination is permitted and reasonable. What if the employee proves an unreasonable or refusal to pay benefits? The employer must prove genuine doubt. We're not going to do a whole bunch about 132As, but let's go over it real quickly because there are also burdens of proof here. The employee must prove what? That they filed claim, or they let folks know that they were going to file a workers' compensation claim before the discriminatory act occurred. And that in response to the filing or becoming aware of the intent to file a workers' compensation claim, the employer discriminated against the employee in some way. And 3, the employer's act singled out the applicant because of the work-related injury. It's not enough to note that the applicant filed a workers' compensation claim and got fired because the employer may have had a non-discriminatory reason to. Similarly, the applicant must prove that they were singled out because they may have been fired, but the entire work staff of that entire shift may have been fired and had nothing to do with the workers' compensation claim. So once the applicant has proven that they filed or made known their desire to file a workers' compensation claim, they offer up proof that they were discriminated against because of that, and that it was a direct consequence of the work-related claim. It's now the burden of the employer to prove, no claim was actually ever filed, and I was never aware of any intent to file, and there was no discrimination because of the claim or intent to file it. It just never happened. Or alternatively, business realities permitted the action. In other words, for example, applicant filed a workers' compensation claim, applicant gets terminated, but the only reason they were terminated was because the job was eliminated for legitimate business reasons. Conclusive presumptions. We talked about rebuttable presumptions. What's a conclusive presumption? A rebuttable can as suggested by the word, can be rebutted. Applicant proceeds to prove something. The defense has the burden of proof unproving it or proving otherwise. Versus a conclusive presumption, which means once it's proven, that's the end of the case. You can't rebut it. There are a number of conclusive presumptions. Dependency is one of the major ones. If you're under the age of 18 and physically or mentally unable to earn, and you were living with the deceased at the time of the death, or the deceased was legally liable to take care of you, it will be conclusively presumed. You will be conclusively presumed to be totally dependent. Now, the defense can come up with all the evidence in the world, could prove that the minor had millions and millions of dollars in resources in the bank, it doesn't matter. The dependent is still conclusively presumed to be a dependent, and there's nothing that the defense can say or do to counter that, even if, for example, they were partially dependent on someone else. Now, if the alleged dependent can't prove 1, 2, and 3, and thus can obtain the conclusive presumption, they can nevertheless prove dependency, but in a non-conclusive way. In other words, in a way that can be rebutted. Total dependency for a spouse similarly can be conclusive. A spouse to whom the deceased employee is married at the time of death shall be conclusively presumed to be wholly dependent for support if the surviving spouse earned $30,000 or less in the 12 months immediately preceding the death. So for this presumption, you must prove marriage at the time of death and earning less than $30,000 in the 12 months prior. At that point, it's conclusively presumed. The defense cannot do nothing to prove otherwise. Once again, the spouse may have millions and millions of dollars in the bank account, may be richer than Rockefeller, and have no true reliance on the dead spouse for support, but nevertheless, it's conclusively presumed, and there's no point for the defense to even offer up that evidence. Fun factoid. I'm saying fun with tongue-in-cheek because I'm being completely sarcastic. Even if the dependent wasn't living with the dependent, or the dependent wasn't actually dependent on the dependent, they still get the conclusive presumption. And as I suggested earlier, if the dependent, so-called, can't prove the elements of the conclusive presumption, they can still prove it via rebuttable presumption. The only difference being with once they've established a rebuttable presumption, the defense can try to prove otherwise. What other kind of conclusive presumptions do we have to deal with? Well, there's the perm total, Labor Code Section 4662. If you lose both eyes or the sight therein, you are conclusively presumed to be 100% perm total. There's nothing that the defense can present to counter that argument. Similarly, if you lose both hands or the use thereof, you are conclusively presumed to be 100%. You are going to get perm total, regardless of what the defense provides. There are two more. If your injury results in, quote, practically totally paralysis. In other words, for all practical purposes, you're behind as in a wheelchair all day. And lastly, you're conclusively presumed to be a perm total if you have a brain injury resulting in incurable mental incapacity or insanity. There I am. It wasn't actually my injury that required my insanity. It's my 5 children and my 3-year-old granddaughter, but enough about me. Would you like to know the definition of these various injuries, loss of the eyes, loss of use of hands, total paralysis, mental incapacity or insanity? So would I. Don't bother looking to the case law because you'll find no black and white rules. You'll get some hints, but no black and white rules. So meaning that at trial time, you can still go to trial as to whether they did totally lose the use of their hands, or they do suffer from practically total paralysis, or they do suffer from mental incapacity or insanity. That's not a conclusive presumption. The conclusive presumption is once those have been established, then the fight is over. Then they get the perm total award. Remember the bad old days? Those of you who've been doing workers' compensation since prior to 2005. Those of you who haven't, back in the bad old days, we would have an award of permanent disability, say to the back of, let's say, 100%. And the applicant later on would get another injury to the back of, say, 50%, or let's say 100%. And we would say, well, wait a minute, you already got a 100% award for your back. You can't possibly get any more. You're done. Go away. You don't get any permanent disability. And the applicant would testify, no. Yes, I know I got 100% permanent disability. And we called it permanent, but turned out it wasn't permanent. I rehabbed myself. I was all better. Give me my second 100% award. Now, this didn't normally happen with 100% awards, but it did happen every day with smaller awards regularly. We saw it all the time. Well, we no longer see the I got better argument. It's precluded per Labor Code Section 4664B. This too was provided to us by SB 899. Quote, if the applicant received a prior award of permanent disability, it shall be conclusively presumed that the prior permanent disability exists at the time of the subsequent industrial injury. In other words, from the defense's perspective, life is groovy. But first, the employer's got to prove the existence of the prior award. So go down to the board, get the FNA, or get the Stipend award, or get whatever it is required to demonstrate that they actually received an award of permanent disability. And then the even tougher part, you have to prove overlap. Now that picture there of the wine glasses, it demonstrates both overlap and also demonstrates how hard it is to get overlap. When you're trying to get overlap, you also may want to get a bottle of wine to ease your pain, because demonstrating overlap is not that easy, particularly not that easy when we're dealing with the AMA guides or we're comparing a pre-2005 permanent disability award with a post-2005 AMA guides based permanent disability award. For those of you who are familiar with the 1997 schedule or earlier, it's easier to demonstrate overlap. Let's say that there was a no heavy lifting prior award of PD, and subsequently in their second injury they suffer from no heavy lifting, repeated bending and stooping. Well, you would give them the PD for the no heavy lifting, bending and stooping, and subtract out from that the permanent disability attributable to the earlier no heavy lifting injury. 5814 penalties, post-award and post-order and award. The WCAB got sick and tired of all the penalties that are arising out of delayed benefits, etc. And these what would often happen in the bad old days is case in chief would be resolved. There'd be an FNA, there'd be a stipulated award, there'd be a CNR, and all of a sudden, out of the woodwork would come a petition for penalties per Labor Code Section 5814. The WCAB said, no, we're going to get rid of that. If you want penalties, your applicant, you're going to have to request the penalties right up front. This is, again, what an SB 899 rescue. Under Labor Code Section 5814C, it states that upon the approval of a compromise and release, findings and awards, or stipulation, it shall be conclusively presumed that any accrued claim for penalties have been resolved, unless it's expressly excluded by the terms of the order of the award. So, if applicant's counsel doesn't bring it up at the time of the CNR, the FNA, or the stipulation, any penalty or potential penalty has gone away. It's time for them to wave bye-bye. The uninsured employer's benefits and trust fund, some more conclusive presumption. Anything paid out by them is presumed to be in a reasonable amount and approximately caused by the injury or death. What about employment? The employee must show at the time of their injury that they were performing services growing out of an incidental to their employment. In other words, they have to prove that they're an employee. Under Labor Code Section 3357, any person rendering service for another other than an independent contractor, or unless expressly excluded, and there are specific statutory exclusions, are presumed to be an employee. But remember, it's a rebuttable presumption. The applicant wants this presumption. They have to prove that they were rendering services to the employer. At that point, the burden shifts. Again, this is not a conclusive presumption; it's a rebuttable presumption, and the burden shifts to the employer to prove that they were actually an independent contractor, that they were otherwise excluded from workers' compensation protection. In other words, there are some folks that look like, smell like, and act like employees, but under the labor code are not employees. And a perfect example is beneficiary charitable nonprofits, folks who are beneficiaries for the Goodwill, or for the Salvation Army, for example, do something called work therapy, and they basically take jobs with the Goodwill, with the Salvation Army as a form of rehab, but because if they're injured, they are not considered employees because the labor code expressly excludes them. All right, we've just gone over time. I apologize for that. We've got a whole lot more to do, and I'm going to have Tammy come on and give you all the particulars of that.